Hey guys, one more run through some of the provisions in a little bit more detail in a little bit more of a relaxed setting. We're going to talk about the representations and warranties. I thought, like conditions, we would run through the precedent to see what's included there, and we'll talk about whether it's customary. We've spent some more time talking about the way that you can vary these concepts, but it's helpful to understand why some of these things are in there in the first place. So although I wouldn't call these template per se, because they're customary, they show up in so many agreements, and you might find little variation from one precedent to the next or one deal to the next in what the substance of a representation and warranty is. How exactly it manifests itself will change based on the facts. So let's go ahead and flip through the section of the loan agreement called representations and warranties. At this point, you should have also looked at that precedent as well as the other precedent. And if you've done so, you'll know that most of these overlap. If you have any specific questions about why there is certain overlap or there isn't certain overlap, definitely raise it in class so we can talk about the factual differences if it's not evident on its face. Okay, let's head to the section. So in this segment, we're going to review the representations and warranties in the drafting precedent. The purpose of this exercise is to point out typical reps and warranties. This is part of the what I'll call template series because although these aren't actually template provisions, they are typical in most finance transactions. So first thing we do is we head to the representations and warranties section, which in this precedent is section 4. Ideally, as you know, your table of contents would be linked. Unfortunately, mine is not right now, but we're almost there. Okay, here we are. So in all representations and warranties sections, as we briefly discussed, the introduction to the section is very important. Here, the representations and warranties are being given with respect to the borrower and each borrower subsidiary. Of course, a structural note, if you don't have any borrower subsidiaries in your deal or they're not relevant to the transaction, then this would need to be revised. Here we have both the borrower and each of its subsidiaries representing and warranting to each lender and the security trustee the following things. As we previously discussed, a representation warranty is a statement of fact, true as of a particular time. And here that particular time would be the effective date and each closing date. And if you look at the definitions, you'll find out what each of those things means. Effective date essentially means when you sign the documents, and each closing date would be the date of each of the fundings. And then you'll notice a caveat, except to the extent that such rep and warranty relates to an earlier date. And that would be something where the statement's being made as of an earlier time, and that specific time is set forth in the rep and warranty. You'll see it in these representations and warranties, but an example would be, for instance, financial statements that, of course, are made as of a close of a fiscal quarter or a fiscal year. So rep and warranty with respect to those would be as of that time rather than as of the effective date or the relevant closing date. Moving on, we've got a number of representations and warranties that I would consider pretty standard, and most of them are set forth here. The first few are with respect to corporate matters, things like organization, corporate authority, and authorization. When you read through each of these representations and warranties, which I won't do for you now, you'll notice this relates to basic corporate powers. These are the things that you probably didn't focus on in your business associations class, but it's really important when you're practicing any type of transactional law that you understand the types of entities that are available and the characteristics associated with those entities and how they work. If you have a borrower signing up to an agreement and it's not permitted to do so from a corporate perspective, then you have a problem because you don't have an enforceable agreement against that party, and any remedies that you've negotiated, any protections you've negotiated in the document are essentially without value. So here we want all of the representations and warranties with respect to those things being made so that we know that the borrower is in fact an entity that can enter into this deal and that we can enforce against if we need to. So that's the purpose of these first few representations and warranties. You may recall this relates back to some of the conditions precedent that we had that required that we receive copies of the borrower's corporate documents, the resolutions with respect to the transaction, and certain legal opinions with respect to the borrower as well. That's because not only do we want them to make these statements here, but we also would like to see the actual documents that they're governed by to make sure that these things are permitted pursuant to those and that they don't create any negative consequences for the borrower that we might need to take into consideration. And we want to see that there's a resolution authorizing our transaction. That might be a standing resolution or it might be something more specific. It generally depends on the type of deal, which type of resolution you'll require. And then finally, we want a legal opinion with respect to the entity to make sure from a legal perspective, all of these things are actually able to be the case. So we continue on. No violation, no consents or approvals. Those generally apply to corporate matters also. Consents and approvals can also relate to other transactions a borrower is a party to, as well as relevant regulatory consents and approvals that they might need. So if a borrower has to go to some sort of a regulatory body or somebody else to get a consent before it can enter into a particular type of transaction, it's telling us here that it's done that and that's been taken care of. If we know that to be the case as well, we might want to see a copy of the consent if that's possible. An example in today's world of how this might be particularly relevant is with all of the government bailouts of various entities. The condition of many of those government bailouts is that the entities borrowing the money actually not enter into certain types of transactions without the government's consent. So if a borrower is entering into a transaction with you, you would want to confirm that it doesn't require the consent of the government. And if it does require the consent of the government, it has what consent it needs to do so. Moving on. No default, no litigation. No default is a statement by the borrower that it's not in default under any of its other financing documents that aren't related to this transaction. This is pretty standard, but it doesn't have to be the case. We require this because we generally view it as a bad sign if they're defaulting under another agreement, and we realize it could impact its value as well as the value of our own collateral if it's in default under other documents. No litigation, likewise, is a similarly standard concept, but this one is one where litigation might be pretty ordinary course, so they may not be able to make this rep cleanly like this because litigation may just be part of their business. If that's the case, then they're not going to be able to leave this rep the way it is. So I'll pause here for a moment because this is a great one where we can stop and discuss a little bit more the techniques we worked on in class, which is figuring out how to take a representation and warranty and make it a little bit more flexible without making it something that the lender entirely assumes the risk on. So the way this no litigation rep is drafted is relatively lender friendly. There are no investigations, suits, or proceedings pending, nor to its knowledge threatened against it or affecting it or its properties. So this rep is absolute with respect to the first part and subject to a certain knowledge qualifier with respect to threatened litigation. If you are the borrower and you are not comfortable making this rep, not because you think that there are investigations, but just that you're not positive, and it's not out of the realm of possibility that there's somebody out there that has decided to initiate a lawsuit against you. You're not particularly concerned about it, but you just don't know if you can honestly make this rep. You might request that the knowledge qualifier be moved to the front of this representation and warranty. As I've mentioned before, from a lender's perspective, this becomes part of our diligence role. We see the markup of this rep, inserting the knowledge qualifier, and it makes us stop and say, wait a second, why do we have to have a knowledge qualifier? It's not that the rep can't be true or false the way that it's written. It's that you're shifting the risk accepted by the parties by adding knowledge qualifiers. Now, if this rep isn't true before we make any adjustments to it, the lender has recourse against the borrower. If there's in fact a suit against the borrower, even if the borrower doesn't know about it, the way it's currently drafted, the borrower would be on the hook. That'd be a breach of rep, and we'd have remedies as lenders under this document for that. If we add the knowledge qualifier, that's no longer the case. It's not that anyone's done anything wrong in particular, and the lawsuit may not even be very relevant. However, it shifts the risk to the lenders in that circumstance, because if we add the knowledge qualifier, the borrower doesn't know about the suit, and there is in fact a suit. Any damages against the borrower that also impact its health for our deal is for the lenders, is basically the lender's problem, because the lender can't go after the borrower and say that the borrower made a false rep. So the lenders prefer a clean rep. The borrower prefers a rep that's qualified, so that it's not making an absolute statement, whether it knows about something bad or not. Now, there are other ways to modify these reps so that they're more borrower friendly, especially if there are specific things on the borrower's mind. For instance, if the borrower is aware of certain lawsuits, and it can't make this rep because of those lawsuits, it may go to the lender and say, I generally don't have a problem making this rep. However, I know about 2 lawsuits, neither of which concerns me, but I cannot make this rep because of those 2 lawsuits, the way it's drafted. A response to that is, okay, we'll qualify this with a schedule. You'll put those lawsuits in the schedule, and then we'll modify the rep to say, except as disclosed in Schedule 1, there are no investigations or suits or proceedings pending. And then the borrower would be covered with respect to its concern. If the borrower sort of says, it's part of my business to have suits against us, we're generally not concerned about them, they're not a big deal, they're usually for small amounts of money, but I don't know about all of them, then we might say, let's use a bucket. Let's say, we are not aware of any investigation, suits, or proceedings pending that in the aggregate would be an amount greater than $2 million. And perhaps the lenders can get comfortable with that. So this is just a good rep to kind of pause and think about the different drafting techniques that we've discussed before. And the last thing I'll say on this rep is the knowledge qualifier before the word threatened. Even though that makes it less absolute and therefore less lender friendly, it's typically acceptable in this circumstance because a threatened lawsuit is sort of a difficult concept to wrap your mind around. It's very broad, and it's question, who's threatened the lawsuit? Is it enough that you've heard someone tell somebody else in an elevator that a company might be suing you? Is that a threat? Does it have to come direct from the company? Does it have to be directly to you? So the word threatened is a little bit of a broad word. So a knowledge qualifier, especially because a threat is not actuality, is typically acceptable in this circumstance. Moving on. Public offering. This one is a little bit less standard, and it really depends on the facts of your transaction. We won't go into the specifics of this one, but this has to do with securities regulation and certain regimes that you might be subject to if there are public offerings. For special purpose, this again relates to kind of the corporate nature of the borrower, but unlike the first few reps, this is about the type of borrower you have. If you have a special purpose entity, it means it's an entity who's only allowed to do certain things by the terms of its corporate documents. You might require one for your transaction because it limits its ability to incur other types of liabilities, and that helps you mitigate risk overall. If your deal is not to have a special purpose borrower, this would not be a rep that you would include. Lesser lien specifically relates to collateral and the documents related to your collateral, such as leases and liens that might be permitted in those documents. Because you have an active contract with other contract parties, that's generally an accepted part of the transaction, you have to permit the terms of those contracts. So that's what this relates to. It's asset specific, so you won't see it in every deal that you do. Filings, registrations, etc. This is generally a rep that you'll see. It basically says that all of the things have been done with respect to the borrower and the assets, so that you've got the security package that you expect. Likewise, Kay goes on to discuss similar concepts. When you have a secured financing, Rep L is going to be very typical, and that is the declaration that you have good and marketable legal title to each of the assets, free and clear of all liens other than permitted liens. Again, very standard if you have a secured transaction, and that's because we need to know that whatever you're securing our deal with actually belongs to you. If you enter into a security agreement and you give somebody a security interest in the Brooklyn Bridge, it doesn't mean much. But if you haven't given them a rep that you actually own it, then possibly you haven't done anything wrong. The fact that we also include free and clear of all liens other than permitted liens is pretty standard. If property is owned and subject to liens, it's obviously worth less in value. And if your deal is that it's not supposed to have any liens on it, or that you're supposed to have a first priority lien, then other liens are problematic. Whether they can be handled is another question and fact specific. And the carve out other than permitted liens is pretty standard. It usually relates to liens that are standard, either accepted by the negotiated terms or subjected to the asset by operation of law. And so it's pretty standard. Also goes to the collateral. If part of our package is ownership of the subsidiaries, we want to make sure that the subsidiaries are owned by the borrower 100%. N is about our security package because we're talking about the Cape Town Convention, which again is an international treaty analog to one of the sections of our bankruptcy code. The purpose of it is to facilitate the financing of aircraft and rail cars by ensuring financiers certain rights in secure transactions. But in order to make sure we can avail ourselves of those rights, we have to know certain facts to be true, and that's the purpose of that rep. O again goes to the asset package and who owns it. P is a secured transactions concept under Article 9 of the UCC. Article 9 of the UCC is the way that we create and perfect our security interest in some of the types of collateral in this transaction. And location of the borrower and the collateral is totally relevant because we need to know which UCC to look at. If the collateral is located in Utah, that's the relevant commercial code. If it's located in Delaware, that's the relevant commercial code. So we need to know where it's located. The UCC defines the term, but of course, things are not always crystal clear when assets are movable or when a company is formed one place but operates in another place. Moving on to taxes, something it's always important to take into consideration, something that always primes anybody's lien, no matter how properly it's been created or perfected, is the government and taxes. So we like to be sure that our borrower is timely with their taxes and that they made all the payments they need to make. So this is a very standard rep as well. Solvency is an important concept from a corporate standpoint. A transaction shouldn't be entered into if the entity won't be legally solvent after the transaction. So we like to get a representation that it's the case that they are solvent. They're not typically allowed under corporate law to do a transaction if they won't be solvent after doing the transaction. But we don't want to find that out after the fact and have to exercise remedies against an entity that's not solvent, which might even render it not in good standing. So we get a representation and warranty with respect to that. S, I'll let you read through, but it applies to certain facts, which if the facts appear one way, means you're subject to certain regulatory regimes, which means certain terms of your contract might be affected, the economics of your deal might be affected, and the remedies that you can exercise might be affected. So we like to have the facts stated with certainty by the borrower in this section of the document. Section 4.2 is with respect to the limited guarantor. Now, as you remember, in our term sheet, we don't have a limited guarantor. But if you have any other type of party that's involved in your transaction offering some kind of credit support, whether it be a guarantee or credit facility or offering collateral itself, then you'll want that entity to provide reps and warranties because once again, you want to make sure that you know exactly who you're dealing with and that whatever the facts are that you assumed about that party when agreeing to their role in the transaction are actually the case. So here we would ask the limited guarantor to make a number of reps. If you're taking a guarantor concept out of the document because it doesn't apply to your deal like we are here, it's very important not to just delete this section out, but to go through each of the reps and warranties and make sure there aren't any reps and warranties that the guarantor made in the underlying precedent that our borrower should instead be making in our transaction because in the underlying precedent, they might have made something with respect to financial wherewithal or otherwise that now is a relevant concept for your borrower to be making. So you'll want to go through the reps and warranties to make sure that nothing should get picked up in your own reps and warranties for the borrower in this current transaction. Likewise, a subordinated lender is not a concept that applies to our transaction, but you should flip through to make sure that there aren't any reps and warranties in there that you could see applying in your own current transaction. Next, we have the security trustee. The security trustee is the entity that acts as trustee for the collateral. It holds it in trust on behalf of the secured parties, which is primarily the lenders. And they make a very limited set of reps. This is standard. It's usually very this actually is closer to template language because a security trustee will give the same reps in every deal across the board. They're very particular about the form to make sure they're saying the same thing in each and every circumstance. But again, it's a very limited set of reps. You're dealing with an established trust company. Their role is really just to hold on to the collateral if there is ever an exercise of remedies, or they might have limited other trustee or agency roles. So what they're repping to is a much more limited set of provisions. And then finally, we have a rep and warranty with respect to the lenders, which is in respect of ERISA. Typically, you don't see lender reps and warranties. You might in the case of something special like an ERISA rep, which we won't go into, but you'll probably learn more about it in practice. But lenders typically don't need to make reps and warranties. So that's something like you to give a little thought about. We'll talk about it in class and see if you can figure out why the borrower has to make them, why the security trustee even needs to make them, why the lender is less required to make them. That's it for now. Thanks.